Welcome to Assist College of Arts and Commerce. This is Assist Edupedia. Myself, Assistant Professor Sunil Shah. Today I would be covering up the topic called Conciliation Officer, which comes under the Industrial Dispute Act under the subject called Industrial Law, which is there in Sem 2 of the class called First Year BMS under the Mumbai University. Today in this particular video, I will be speaking about the disputes. What type of disputes which are arising between the employer and the employee, or between the employer and employer. So this type of disputes has to be raised. So in this particular video, I will be speaking about the dispute between the employer and the employee, which is governed under the Industrial Dispute Act 1947. The Government of India under the Industrial Dispute Act had asked to appoint a conciliation officer. Today I will be speaking about what do you mean by conciliation officer. A conciliation officer makes an effort to resolve the disputes if there is any between the employee and the employer. Between the workmen and the management, the words and the duties of the conciliation officer has been laid under the section 12 of the Industrial Dispute Act 1947. Now speaks about the appointment. The appropriate government may be the central government or the state government as the government thinks fit, and if that particular industries which belongs under the union territory, then it will be appointed by the central government. The appropriate government by notification in the official gazette appoint as such number of conciliation officer as they think fit, and they have been charged with the duty of mediating in promoting the settlement of industrial disputes. So the main process of the conciliation officer is to settle the dispute between the employees and the employer, or in case of workmen and the management. Coming to the next part, what are the role of the conciliation officer? The conciliation officer, if you see from this particular side, is a voluntary process in which the professional facilitator assists the employers and the employees to resolve the dispute which is arising during the course of employment and which not be further to be assisted. The process can be described as a facilitated search of agreement between the disputing parties. So under the Industrial Dispute Act, the facilitator, the conciliator will think as such many conditions when and there won't be any dispute, or if there is a dispute, they will try to resolve at earlier stage. Coming to the next point, what are the duties? I just spoke about the rules of the conciliation officer. What are the duties? Where the industrial dispute exists or it has been apprehended, or the conciliation officer feels that the dispute may be arising, that is called apprehended, the conciliation officer may, or where the dispute relates to the public utility service. The public utility service are those particular services which are being covered, which are essentials like rail, road or bus or the taxi, or such a whether which is necessary related to the service related to the newspaper. So in such cases, before going into the strike, the notice has to be given, and under there is a dispute settlement, it should be given the notice under section 22 of the Industrial Dispute Act to hold the conciliation proceeding in the prescribed manner. So notice is compulsory when they want to go under the section 22 to when there is a disputes in case of public utility service. Whereas if there is a conciliation officer for the purpose of bringing about the settlement of the dispute without delay, investigate the disputes and all the matters affecting the merits of the rights of the settlement thereof, and may do all such thing which is necessary for the purpose of inducing the parties to come with the fair and amicable settlement of the disputes. So what is the role of conciliation? He will try to resolve the dispute rather than aggravating the situation. In case of factory, because if there is a loss to the factory, there would be loss to the nation, and if the factory or the company is not performing, then there is the chances of the lockout of the particular organization that may be losing the job. Coming to the next part of the duties, it is a settlement of the dispute for any other item. If the disputes are around in the course of employment, the conciliation officer shall send a report to the appropriate government or the officer authorized in this behalf by the appropriate government, together with the memorandum of settlement if the settlement is coming across, and with the supporting evidence. And if the settlement is arrived, the conciliation officer as soon as the practical solution should give the practical solution to the dispute resolution, and after investigation of the case to the appropriate government, and the full report for the steps to be taken out for the settlements has to be described, and the circumstances in case where the disputes are not been resolved, then that particular statement has to be mentioned in his report, and that should be supported with the documentary evidence. Coming, what is the position of the conciliation officer? The conciliation officer is not accessing, not at all accessing extra judicial or quasi judicial powers or the authority, nor is a quasi judicial or judicial authority, but is the pure and simple administrative function. So it is not having the quasi judicial power. So it is not a judicial officer, it is an administrative power what is exercising in his position. Coming to the qualification of the conciliation officer, he is been a deputy chief labor commissioner central or a joint commissioner of the labor department, having a degree in law, at least 7 years of experience in the labor department, including 3 years of experience of the conciliation officer, would has to be the qualification before he has been appointed as a conciliation officer during the course of proceedings of the settlement of the disputes. Coming to the role of the conciliation officer, the conciliator may conduct the conciliation proceeding in such a manner as things fit into and taking into the account of the circumstances of the cases as the wish the parties may express, including the request by the party that he as a conciliator to hear the oral statement and there is a need of speedy settlement of the dispute between the parties. Coming to the principle, the conciliator shall be guided by the principle of objectivity, fairness, justice, giving consideration to among the others, the right and obligation of the parties, the usage of the trade concern and the circumstances surrounding a dispute, including any previous business practices between them, the parties. So this principle is to follow while giving the judgment. Coming to the proceedings, how he should proceed, the conciliation officer means a process whereby the parties have a mutual consent, appoint a conciliator or the conciliation officer to assist them in the attempt to reach the amicable settlement of the industrial dispute arising between the contractual relationship. Section 4 of the Industrial Dispute Act speaks about he authorizes the appropriate government to engage as such number of conciliation officer as number of the industries or upon that particular jurisdiction where the factor has been located for discharging his responsibility for mediating in between the employers and the employee or between the workmen and the management for the settlement of the disputes. Coming to the process, if I go from this particular pie diagram, there should be a meeting between the employer and the employee, then there would be a recording of the statement, would be the suggestion given by the employees and the employer or by the conciliation officer, and there would be memorandum of understanding if there is a solution error between them. Coming to the what are the conciliation machineries under the Factors Act, the conciliation machineries are the work committee where there is equal number of members in the work committee from the employer side and the employee side, conciliation officer which has been appointed by the labor court, the courts of inquiry when there is a matter going beyond the conciliation officer would be labor court or industrial court, or there should be conciliation board who appoints the conciliation officer. Coming to the dispute resolution, under the conciliation, if there is a dispute, there would be individual conciliation when there is a single worker and the employer, if there is a dispute type, and if there is a collective conciliation which is required if mass number of workers or number of workers are more going where the conciliation is necessary if they are going against the management. So conciliation would be individual or conciliation can be collective. Coming that the conciliation process, it may be voluntary if there is a agreement between the employer and employer, or it may be compulsory as per the decision of the labor code. Coming to the conciliation officer, the conciliation officer would be mediating between the employer and the employee. He may be promoting as number of the steps which is required for the good and cordial relationship between the employer and the employee or the workman or the management, and they should arrive with the settlement within 14 days of the receipt of the complaint. He should try to settle the industrial disputes. Coming to the what are the in the industrial dispute, which are the industrial dispute machinery. First is conciliation. There would be work committee, conciliation officer and the board of conciliation. If it has been failing, then there would be arbitration. As per the Arbitration Act, the proceedings would be followed and it would be related to the court of inquiry. It would be labor court or the industrial court. In case of adjudication, there would be labor court, industrial tribunal or the national tribunal depending on the merit of the cases. Coming out the whole, if you see from this whole particular chart, the industrial dispute resolution mechanism and the industrial undertaking, there would be work committee, then under the work committee there would be a conciliation officer who has been appointed by the central government or the state government, then there under this Under the industrial tribunal, there would be also one more called arbitral tribunal. Who would be the third party would be hearing the decisions between the employers and the employee, and then he would be going for the award. Under the labor board, the board would be labor court. The labor court would be also awarding the judgment, awarding that decision, that would be called as award. If there is a matter going into the national tribunal or this labor tribunal, then they also have that particular thing of giving the judgment, that would be called as award. So award would be from tribunal, it would be from labor court, or it would be from the arbitral tribunal, and whole process would be called as award. So it would be award to the employer, it would be award to the employee also. Now coming to this particular chart, where the students, you can understand properly what are the machinery for handling industrial dispute. There would be preventive machinery, that is voluntary, which is non-statutory, workers' participation in management. There should be collective bargaining for the benefit of the employee. There would be grievance procedure. The procedure is to be followed if the workman or the employee is not satisfied with the procedure which is being laid by the management. There should be tripartite bodies. There would be three parties, who would be third party would be something away from the workers and management, and it would be the code of discipline has to be exhibited or displayed at prominent places in the industries or the factory, followed with the standing orders which are to be displayed, that is called standing operating procedures, or the standing orders has to be displayed at prominent places. Coming with the settlement machinery, which is statutory, this is preventive machinery and this is statutory machinery. Under the statutory machinery, we have conciliation officer. The conciliation officer would be from the conciliation board or the conciliation officer under the conciliation. Second would be court of inquiry, when directly the court will inquire into the matter. Following would be voluntary arbitration, if the employee or the employer both goes for the voluntary arbitration to the third parties other than the parties from within the management. And there would be adjudication. Under the adjudication, we have labor court. If there is a dispute, where we will go to the labor court. If the person is unsatisfied with the decision given by the labor court, then they will approach to industrial tribunal. And if the person is not satisfied with the decision given by industrial tribunal, they will go to the national tribunal. So these are the hierarchies which have been done, but the person cannot go directly to the national tribunal, but he has to go through step by step, that is called labor, then industrial, and would be national tribunal. Thank you from my side, students. Under this particular video, I am explaining you what the procedure, the rules, and the way in which the conciliation proceedings has to be carried out. Thank you from my side.